give me a second, Mr. Buck, if you would, to get my screens back in order. When people sit in here when I'm not here, they put them... Nothing's working, I guess. Okay, fire away.
Thank you very much, my lord. Good morning, your lordships. I appear on behalf of the appellant, FMC. My learned friend, Mr. Adamson, appears for the respondent, Fastmove. The interested party, Mr. Salaman, is not in attendance. I think there's some...
So you're going to have to speak up a bit, Mr.
Do apologise. I'll speak up. I'm sorry, my lord. I appear on behalf of the appellant, FMC. The respondent, Fastmove, is represented by my learned friend, Mr. Adamson. My lords, I hope you have 4 bundles. There is a core bundle.
Yeah, but don't worry about the bundles. I think we've got all those.
All 4. Thank you very much, my lord.
Yeah.
In respect of this hearing, I've had discussions with my learned friend which have been productive in respect of how we will propose to deal with the matter.
Yes.
It is a rolled-up hearing, but we're proposing to deal with the substance of the merits of the appeal, along with the issue of permission to appeal. That includes the issue of the lateness of the application for permission to appeal. In respect of the 2 other applications, again, we've had discussion in respect of the application to rely upon the second judgment, that of the learned judge below, dated the 11th of July, we both are of the view that that does not constitute new evidence. It is essentially a judgment arising out of the adjourned summary judgment application, and therefore there's no requirement for a formal application or permission to rely upon that judgment.
No, I think what really matters is whether you should have permission to appeal. So shall we try and address that question? And then the lateness question comes only, really, if you're likely to be getting permission to appeal in the first place, or have your appeal allowed.
Quite, my lord, yes. So what I was going to propose to do is deal with the substance of the appeal, which will therefore encompass the issue of leave to appeal. And I was going to address your lordships in respect of various matters. If I could just outline what those are, because I'm sure your lordship have done extensive reading, so if I can shorten the hearing by shortening my submissions, then obviously I will do so. I was going to address your lordship just briefly as to the background of the claim and how it came on before the learned judge below, i.e. the extent of the application for summary judgment. Then move on to judgment 1 and take your lordships through judgment 1. A very brief explanation of events post judgment 1 up until the hearing on the 14th of May, which then resulted in judgment 2. Take your lordships through judgment 2, and then at the end deal with the issue of the lateness. My lords, if I could therefore commence with submissions relating to the context of the decision under appeal. My lords, you'll have seen from the papers that this claim was issued in January 2023 in an application for summary judgment made by Fastmove, the claimant, on the 30th of November. that then came on for hearing on the 14th of October.
Yeah, we don't need the dates. We've got all those.
Thank you, my lord. Where there was no defences filed by any of the defendants for the purposes of that application. In respect of matters of fact, for the purposes of the application and the judgment, that's set out at judgment paragraphs 21 to 24 within the core bundle at page 62. In summary, the arrangement between the parties operated for the purposes of the application on the footing that Fastmove collected sterling notes from the UK, Fastmove dispatched those to Singapore, where they were received by my client, who then counted and verified those notes, and then transferred those notes or exchanged them in return for Singapore dollars, again notes. They were then passed on physically to Billpay, who would then convert them into US dollars as a credit into Fastmove's account held by Billpay, and then Billpay, on instructions from Fastmove, would make payments from that account to Fastmove's nominees. And my lords, you'll note, please, at paragraph 24, there was an accepted basis that, in respect of my client's controlling mind, Mr. Jalaluddin.
Wait, your client is a sole trader, isn't he?
He's
not a controlling, he's not a company.
Well, I think they have the position in Singapore as some form of limited liability entity. But, my lord, for the purposes of this hearing, I'm happy to proceed on the basis that they're one and the same.
Well, I don't think they're one and the same. I mean, even in Singapore, they have a difference between a corporate entity and an individual. Which is it? Your client must know. You've got instructing solicitors. Is it an individual, Mr. Jalaluddin, or is it a corporate entity? Or is it a limited liability partnership? Or is it something else known only to Singapore law, which you're going to tell us about?
I understand it's a registered sole proprietary.
A registered sole propriety?
Yeah.
What does that mean?
I'm afraid I can't assist the court as to that position under Singapore law. What I do know from the papers, my lord, is that there was a freezing injunction obtained originally as against that registered thing, maybe my individual client, Mr. Jalaluddin, and then there was a second later freezing order against him personally. So I don't know whether that reflects some difference in Singapore law as to the status of that, my client.
So there were enforcement proceedings in Singapore. What's the status of those at the moment?
I'd again have to take instructions, my lord.
Because Mr. Salamat was sentenced to 3 months imprisonment in Singapore, was he not?
I have no instruction. I don't know that, my lord.
Okay.
I don't know whether my learned friend can assist.
He was, my lord.
Did he go to prison?
I don't believe so, no, because he's out of the jurisdiction, out of Singapore.
No, but he was sentenced. Oh, you see, he's out of Singapore.
He's not in Singapore.
Not in Singapore. Okay, thank you.
My lord, can I just explain? Obviously, I wasn't counsel below, and therefore my knowledge of events in respect of what took place is more limited than might otherwise be. I think it's the same for my learned friend, so I do apologise to the extent I can't assist.
Yes, well, it's not very helpful for the court. I mean, this is an extremely difficult case to understand the commercial realities, is it not? Do you have any instructions as to those?
Well, I think the evidence that we provide was that we asked whether it was legitimate, and we understood it was legitimate. But there is, I think, an issue.
You're operating in a shopping centre in Singapore, and you're taking in suitcases full of pounds sterling and converting them into suitcases full of Singapore dollars. And your case is that that's legitimate without. Do you have a license to do that?
I would again have to take instructions as to whether my client had a license.
Yes? What's the evidence, not instructions?
My lords, I'm instructed that he did have a license for the activity.
Did have a license?
Did have a license.
Okay.
My lord, in respect to the application for summary judgment, it was brought and heard on a limited basis as to whether there were breaches of contract by my client and also by Billpay as the first ground. Second ground was in respect to whether there were breaches of trust. And then the third ground related to Mr. Salamat as to whether he had procured breaches of contract. So there was a limited basis upon which the court below dealt with the matter.
But that's the problem, isn't it? That your case is, that's the problem. There was a limited basis on which it was dealt with first, and then the judge came to a conclusion based on new evidence that you say is inconsistent with the first judgment.
What we say is that there was a hearing of the summary judgment application in respect to my client and Billpay, and also Mr. Salamat. In respect of that hearing, there was judgment entered against my client for breach of contract, not breach of trust. There was judgment entered against Billpay for both breach of contract and breach of trust, and that the issue of the claims against Mr. Salamat were then adjourned off with liberty for him to file further evidence as he wished, including a defence as he wished. That further evidence was then provided by the court, and the court then determined that the summary judgment application against him was to be dismissed, and it was dismissed. And we say that in respect to judgment 1, my client essentially lost on a construction of the agreement in issue on the basis that the 5% agreement, as alleged, was not compatible with the terms of that agreement. But then, in respect of the adjourned matter, we say the court didn't maintain that position, in that what had been put forward to the court for that adjourned hearing was evidence of the agreement, and also the fact that it was therefore compatible with the existence of the written agreement. And on that basis, that application as against Mr. Salamat, the third defendant, was then dismissed. And we say that that was an outcome which was inconsistent with the first judgment, because on judgment 1 you had a determination that the alleged 5% fee arrangement was not compatible with the terms. That is not continued through on judgment 2, and in fact the result of the judgment is the dismissal of the application for summary judgment in its entirety against Mr. Salamat on both issue 1 and issue 2 as defined within that judgment. In circumstances where Mr. Salamat put forward a defence which is now going to trial, which does allege breach of contract. That there was no breach of contract, forgive me, my lords. So we have a situation in which there's going to be a trial where one of the issues is that there has been no breach of contract by Billpay, and because of the nature of the agreement, if Billpay is not liable for breach of contract, then my client is also not liable. So that is a live issue for trial. Yet it's been determined against my client that there was a breach of contract. And we say that's a fundamental inconsistency. And it has been driven by how his lordship, the learned judge, dealt with the matter by adjourning off the application essentially part heard, allowing fresh evidence in and a defence, which actually meant that his judgment, which was then provided on judgment 2, was inconsistent with judgment 1.
Well, they say it's not inconsistent because the only issue against Salamat is the question of whether he genuinely believed that there was an enforceable commission arrangement.
Well, I submit that one properly read judgment 2, that's not what judgment 2 determines. Judgment 2 keeps open the issue of issue 1. And I can take your lordship's direct to that point if that would assist at this stage.
Just before you do, have we got the order which was made following judgment 2? Maybe we have, but I couldn't find it.
I don't believe we have the order from judgment 2. It is recorded, though, in the terms of the judgment 2 at the end, my lord.
Right, well, we ought to have the order, please.
We'll ensure that the order is provided.
So you say it's at the end of the judgment.
So if one looks at judgment 2, which is in the supplemental bundle, my lord.
The parties are in the process of agreeing the terms of a minute of order.
But I was talking, my lord, in respect to paragraph 54, the application of a summary judgment against Mr. Salamat is dismissed.
Yeah, but when my lord was asking what are the terms of the minute of order, which is going to be with the court later today.
I'm afraid I haven't had sight of it. I don't think those instructing me have.
Well, the question is, what does it do more substantively than dismiss the application for summary judgment against Mr. Salamat?
I can't assist.
Well, I think we need to know. Does it, Mr. Addison?
I'm afraid I don't know the answer to that question either, but we'll find the order.
Right. Where do you want to go now?
Sorry, can I ask one other question, which is that if we were to allow your appeal, what, if anything, do you say we should do about the judgment against Billpay?
Well, my lords, the position is Billpay has not appealed that order. So I recognise that the court might take the view that that order, in the absence of an appeal against it, should remain, but I would submit the proper course would be to set aside that order as well.
What is Billpay? Is Billpay a corporation in Singapore, incorporated?
That was my understanding, my lord, yes.
And we understand that Mr. Salamat disassociated himself from Billpay as a result of the proceedings or the dispute. Is that right?
There was no acknowledgement of service filed on behalf of Billpay, no defence filed, and no representation in respect to these proceedings. Ever. That's my understanding, my lord, yes.
So on what basis could we set aside the judgment against Billpay?
My lord, again, I recognise there's a jurisdictional issue in the sense that there's been no appeal against that decision.
No, I mean on what jurisdictional, on what legal basis could we set aside? Could we set aside that judgment of our own motion if we thought it was unsatisfactory?
I would submit you could.
I mean, I imagine Fastmove would say we can't, but what do you say, since you've submitted that we should?
My lord, I would say you do have the jurisdiction to set aside that order.
I mean, you can't, with great respect, Mr. Buck, you can't just shrug when you made a submission that we should set aside the order against Billpay. You can only make that submission if you can support it with some basis. I mean, is there a... I mean, I'm not aware. I don't know whether any of my colleagues are aware of a provision in the CPR that says you can.
If I could come back to that, my lord,
Yes, okay.
My lord, I was going to proceed by reference to Judgment 1, first of all, to set out the basis upon which the court dealt with that.
Right. Well, we have read Judgment 1, but you take us where you would like us to go.
My lord, the position in respect of the application, as I said, was limited to the breach of contract, breach of trust, and then the issue of procurement of the breaches. In respect of how the learned judge below dealt with the matter, beginning at paragraph 28 of the judgment, which is at page 63, there was, first of all, an argument raised essentially by my client, FMC, as to the proper interpretation of the agreement, seeking to avoid a situation in which my client was liable along with Billpay, and that was rejected at paragraph 33 on the basis that the contractual obligations were indivisible as between those two parties. I say that's important, my lords, because any determination as to the liability of Billpay would also follow as to the liability of my client, because they're under the contract for breach of contract, because of the indivisibility of the obligations created by the agreement.
Well, there's no provision in the agreement, is there, that provides for separate obligations, except I think the provision that says that Billpay is, I can't remember the provision, but there is one that separates out Billpay, isn't there?
I think for the purposes of the appeal, and in respect of the nature of the claim, which was that there was essentially a shortfall in the monies received back, there's no argument, viable argument as to...
It's all suppliers.
It's all supplier. And so I don't argue anything, and I don't suggest the learned judge was incorrect in making his assessment there. Rather the contrary.
Okay, so 33 is correct.
33 is correct, my lord. Then you have 35, which identifies the reference in the evidence of Mr. Salamat as to the existence of a charge of a further 5% of the dollar equivalent of the money shipped to Singapore. And it is put forward on the basis that that can explain the shortfall. And that is determined in paragraph 36, and it's rejected on the basis that it's contradictory and incompatible with the terms of the agreement, and in particular clause 6. Which your lordships will have read clause 6, no doubt, but I can take your lordships to it if you wish.
Which page is it?
It's within the core bundle, my lord, at page 109. So any agreement as between the parties for a charge to include the 5% had to be in writing, and it was said that there was no such writing.
Well, it went a little bit further than that in 36. It wasn't alleged that there was anything in writing.
Yes, my lord, it was an oral agreement at that stage. That was what it was put on, the foundation of. There was a distinct lack of particulars there provided by Mr. Salamat as to the basis on which that assertion was made.
Well, he just alleged an oral agreement full stop.
Yes, my lord. Yes. And that was what was rejected in paragraph 36 as being incompatible with the existence of the terms of the contract.
But there's something a bit unsatisfactory about this, because the judge in Judgment 1, where the parties were D1 and D3 and Claimant, finds that there is no conflict because what was alleged was an oral agreement. Right? And therefore the oral agreement is in conflict with clause 6 of the written agreement. Judgment 2, to which the only parties represented were Fastmove and Salamat, is that right?
Judgment 2, it was, yes, my lord, just Mr. Salamat and
Fastmove and Salamat. Salamat changes the goalposts and says it's a written agreement, and the judge says that's an arguable case, and I can try whether there was a written agreement varying the banknotes agreement. And if that happens, then your judgment is unsafe, I suppose. You
yes,
would say.
That's the point, my lord.
It's wrong if that happens.
Because you have two conflicting positions. You have this 5% arrangement, this fee arrangement.
But you can't say that this judgment on its face is wrong.
No, I don't.
You don't.
No, what I do say is procedurally it's wrong, though. So in respect of its application and determination of issue 1, it's wrong. It's not wrong in its reasoning, but that the error created by the permission to adjourn off the summary judgment application against Mr. Salamat with a broad ability of Mr. Salamat to file further evidence and also a defence. And my lords, when you read what the court permits at paragraph 66, it's a wide-ranging ability of Mr. Salamat to give instructions to his lawyers, essentially to establish if he has a defence.
He was represented, Salamat,
Yes, he was, my lord, yes.
in Judgment 1.
And Judgment 2. And it begins at, the relevant point, my lord, begins at paragraph 65, because it starts, on the face of it, there is no justified reason for withholding the 1.9 million, and the reasons subsequently given by Billpay, Mr. Salamat, in his witness statement, are either contrary to the terms of the agreement or unreal. But there's no determination as against Mr. Salamat to that effect. What it says is on the face of it. And then the learned judge below goes on in paragraph 66 to say that he'll adjourn off that aspect of the application with permission to restore, with an unlimited ability of Mr. Salamat to supply further evidence in support of his position in response to the application. So it is again wide. The application may then be restored. This course gives Mr. Salamat the opportunity to provide his instructions to his lawyers and to give such evidence as he may to establish that he has a defence with a real prospect of success. And therefore,
It looks as if what the judge had in mind was that the further evidence and defence would be concerned solely with the question whether he had personal liability for an established breach, but the terms of his order and judgment did not confine it to that. And what happened was that it broadened out to the question whether there was a breach.
exactly, my lord, yes, that's the position. And there was no determination in Judgment 2 that those points as to whether there was a breach were not permissible to be raised by Mr. Salamat. There was a defence filed, or there was an amended particulars of claim, which in fact didn't identify that this issue had been determined. And in fact, the way it was colour-coded, which was quite unusual, left the position whereby the issue of breach was still to be determined at the adjourned hearing, and then a defence was filed by Mr. Salamat, which expressly states that it is denied that there's a breach of the contract.
Well, that's why we need to see the order after Judgment 2, which will state definitively what the position is.
And then at that hearing, whilst the issue of estoppel was raised in submissions, counsel, Mr. Cohen of King's Counsel, on behalf of Mr. Salamat, made submissions directly to the point that there was no breach because the actions that had taken place fell within the terms of the agreement. That was what was positively said to the judge. Obviously, the response, and I don't have the transcript, the response was on behalf of Fastmove, no, that's already been determined. But the learned judge below doesn't deal with that issue. He says it's an argument to be had. And the critical paragraphs, my lords, are the discussion section commencing at paragraph 44 in page 51 of the supplemental bundle. Was what's said there.
Sorry, could you say that?
Page 51 of the supplemental bundle, my lord. Actually, may I ask, first of all, for your lordships to look at page 38, which is paragraph 6 of that judgment, where he sets up...
This is the second judgment.
This is the second judgment, my lord, yes.
Paragraph 6.
Paragraph 6. So this section follows from a reference to the amendments of the particulars of claim provided by Fastmove, and at this point the defence has been filed along with the second evidence, witness statement. And that what's said there is a reference to the oral agreement that they'll be liable to pay Billpay for a commission of 5% of the money being transferred. And then it said that this oral agreement remains at the heart of Mr. Salamat's defence in the simple terms, and there's Roman 1 and Roman 2. Roman 1 is the breach of contract point, Roman 2 is the dishonesty allegation against Mr. Salamat. And you'll see there in Roma 1, it was said that that gives rise to a triable issue. So it's all in the context of the summary judgment application.
It's funny that he describes it as an oral agreement, because by this stage, the defence that was being raised is that this was evidenced in writing.
Well, I think it's said to be...
Otherwise, you'd have been back to square one.
Yes, I think it's being said to be evidence in writing by the process that was introduced.
Yeah, but it's not an oral agreement. It's something which satisfies the requirement for writing.
But it's pleaded out in the defence, and one can see how it's pleaded out in paragraph 7. There's a reference there to how Mr. Salamat's defence puts it, that the agreement, this fee arrangement, is in any event compatible with the agreement. And that seems to be conceded at paragraph 45 of the judgment.
Conceded?
Would appear to be.
Conceded by Fastmove?
By Fastmove, yes. Because there's...
45.
Yeah, so when one moves on, then you get to paragraph 45, beginning at 44, if I may, my lord. Again, just for completeness, paragraphs 41 to 42, there again is submissions being made and recorded to be made by Mr. Cohen on behalf of Mr. Salamat, on the basis that the fee arrangement works as a matter of law. And it says it took the involvement of lawyers to identify the importance of the document to the point about the 5% fee. So again, the conversation appears, or the submissions that were being made below, appear to be not just to issue 1, but not just to issue 2, but to issue 1. And then we get onto the discussion section. It begins as set out above. There are 2 aspects to Mr. Salamat's defence. I infer that to be issue 1 and issue 2. The first is that Billpay was not in breach of contract, or there is a triable issue as to that. There is then a reference there on behalf of Fastmove to the question of issue estoppel. And then the learned judge carries on at paragraph 45. There may be an interesting argument to be had. And I said that must be a reference to at trial, given his determination later that it's to be dismissed. The application for summary judgment to be dismissed.
Well, it's not clear what he's talking about, because he could be talking about the argument as to the case at the previous, what the case was at the previous hearing, because of the factual dispute about whether Billpay were entitled to withhold the money. And his first witness statement relying on the agreement of 5%. You say that must be an interesting argument as to whether the judgment in breach of contract, as to the breach of contract, was sustainable.
Yes, my lord. But paragraphs 45 and 44, I believe, are talking about... And
then he says, to what extent did that leave... he allowed Fastmove to plead a fuller case of fraud.
Salamat, Mr. Salamat.
No.
He allowed...
to plead a fuller case of fraud, and Salamat to provide a defence and further witness evidence. And he asks whether that left it open to Salamat to continue to argue the merits of issue 1.
Yes, my lord, which is the breach of contract issue.
But the point was not explored in any detail because the evidence Salamat gave went to both issues, and the real question was issue 2.
Yes, my lord. And the point is at the bottom...
So he doesn't answer in this judgment the question which he has posed.
No, he doesn't. He doesn't at all.
But it's also odd at the end of 44, the last sentence. At the previous hearing, the issue, his case was that the summary judgment should not be granted because of the factual dispute about whether there wasn't a factual dispute. There was no evidence to satisfy condition 6.
No.
There's a sort of muddling of factual issues and legal issues throughout much of the discussion.
Yes, my lord. And it seems to have fallen on the basis that there was not much discussion because it seems, for the purposes of this hearing, that the parties were proceeding on the basis that if Mr. Salamat was successful on issue 2, i.e. saying that there was an arguable case as a matter of fact as to the existence of this 5% arrangement or agreement, that in itself would therefore determine the matter, determine the application. So if Mr. Salamat was to lose on that point, then he would also obviously lose on issue 1. But what's not addressed is what happens if Mr. Salamat is successful on issue 2, because then that raises the question, does it also follow that he's going to be successful on issue 1?
Can I bring you down to earth, Mr. Buck? If you are going to succeed in this appeal, you have to show that the judgment which you are appealing, or the order that you are appealing, more particularly, is affected by an error of law, or possibly fact, but in this case I think it's likely to be law. And I would like to know, what is the error of law in the first judgment that you rely upon? Or if you like, fact. I mean, the error may be a fundamental procedural error, but what is it?
But the error is...
Well, let me just finish. Because if there is not one, then the fact that it's all very unsatisfactory may not avail you.
I understand, my lord. My submission is that there was an error of law in the fact that there is an inconsistent judgment between Judgment 1 and Judgment 2 as to the treatment of the issue of the fee.
Well, that is not an error of law in Judgment 1, unless you can point, I mean, helping you out,
I was going to come on to...
Unless you can point to a fundamental procedural error in deciding one part of summary judgment, but not the whole of the application, as being a fundamental error. But it has to be apparent from the face of the first judgment or the first order that that was an error.
Yes, my lord.
In other words, you have to go so far as to say what he did in the first judgment was never going to be satisfactory in the event that Mr. Salamat was given leave to defend.
And that's our ground 2, which is the procedural error, which is to adjourn off part heard that application and that hearing, having given a essentially part judgment, which is Judgment 1, to permit Mr. Salamat unrestricted ability to file a defence with, again, unrestricted witness evidence in support of his position, which then resulted in Judgment 2 and a dismissal of the application.
Well,
so we say that's the procedural error, which then highlights the fact that you essentially have one hearing split in half, bifurcated. First half results in a Judgment 1, which is incompatible with, when the matter is returned, Judgment 2.
But on one analysis, that's not an error, not a fundamental error anyway. It may be, as a matter of case management, rather unsatisfactory, but it's not a fundamental error because all he had to do when it got to the second stage was say, well, I did give you permission to file a lot of evidence and file a defence, but you can't impugn my first judgment.
My lord.
And so, as a result of my first judgment, you can't say there wasn't a breach of contract. You can only say, I thought there wasn't a breach of contract.
I can see that if, as a result of Judgment 2, there is an order which says that there can't be any challenge to the finding on Judgment 1, then the appeal fails. I accept that, my lord.
Sorry, say that again.
So I accept that if, in reality, Judgment 2 went on to provide that that Mr. Salamat was not entitled to raise the argument as to the compatibility, issue 1, the compatibility of the agreement with the clauses, I accept that if that was a finding at Judgment 2, then there would be no appeal, because Judgment 1 and Judgment 2 would then be consistent. But that's, again, we need to have sight of the order, I recognise that, but looking at the...
No, I mean, my problem is that you don't just have to show that what he did created later unsatisfactory consequences. You have to show that what he did was wrong in some way. If it's a matter of law, then it's a legal error that he made. If it's a matter of fact, then it has to be some or procedure, then it has to be some, actually it's not procedure really, it's case management.
It is, my lord.
A much higher hurdle. But it has to be wrong at the time it was done, not shown to be wrong by some further mistake made in a different case that is not appealed.
But I say that the decision was wrong in judgment 1, which is to adjourn off with that liberty to file a defence and any evidence.
But it wouldn't always be wrong if Salamat had just done what the judge thought he was going to do and said, I didn't think, despite what actually you held, I didn't think that it was inconsistent for me to agree to be paid 5%, Billpay to be paid 5%, and so I shouldn't be held to have been a fraudster. I mean, that's what the judge envisaged, and okay, that you may say, well, paragraph, whatever it is, 66 of the original judgment is a bit ambiguous as to what he was to be permitted to do, but it's very hard to say that that is something we can now overturn because of what happened subsequently. That's my problem.
My Lord, in respect of there was no limitation in respect of the defence and witness statement, and that is recorded in the order. Well, not recorded in the order in express terms, but you have judgment being entered against the first and the second defendants.
Where is the order?
It's within the court bundle, my Lord, at page 48. And in the recitals, my Lord's halfway down, it's upon the court noting that the amended particulars of claim contain green text highlighted by the claimants which are not relevant to the application. And that's the point I made, that when one looks at the actual amended particulars of claim, the issue of breach is still in black, it's not in green. And then what is the learned judge then went on to do, if one looks at page 49, is to enter the judgments against the first and second defendants, and as against the third defendant, from paragraph 9 onwards, page 50, is to simply adjourn off that application. My Lords, I've been provided with a copy of the order arising from the second judgment. I think copies are being provided.
So this order says the claimant's application against the third defendant is dismissed. No order for conditional leave to defend. Claimant and third defendant file and serve written submissions about the costs. Parties have permission to amend the pleadings. Has permission to file and serve an amended defence. Claimant has permission to serve a reply. And they're going to agree about a time estimate for CMC.
And my Lord, in respect to that defence, I don't have a copy of the amended defence. I do have a copy, I received it last night, a copy of the defence from the third defendant. And that does include an assertion that there was no breach of contract, as against both Billpay and also FMC. I do have copies of that full defence, which I can hand up to your Lordship if you wish. But I think it's common ground that that's what is within the defence. And then the reply that's filed by Fastmove is an assertion that Mr. Salamat can't challenge the finding at Judgment 1 that there was a breach of contract by both Billpay and FMC. So those are live issues which are going towards trial.
Yes.
And again, my learned friend grateful for being provided with copies of that reply if your lordships wish to have copies provided.
We do.
I may pass up also the defence at the same time.
Can these all be provided electronically?
Yes, my lord, they will.
Thank you.
The clearest statement from Mr. Salamat as to a position as to breach of contract is contained in paragraph 29, which is
Of
a response of the defence.
29.
And in respect to the reply, the relevant paragraph is paragraph 3.
It's said to be an abuse of process.
Yes, my lord.
Yep.
But that is a matter that was raised in submissions at judgment 2, but not determined by the learned judge. But the effect was that the application for summary judgment was dismissed. That was the outcome of judgment 2. And it wasn't a limited dismissal on the basis that that issue 1 had been determined and was therefore binding on Mr. Salamat. It was that the entirety of the application, including issue 1 and issue 2, which had been argued before the learned judge below, that application was dismissed. So, my lord, we say that the procedural error was significant.
What do you say the procedural error was, precisely?
It is the decision to adjourn off part of that application and to provide Mr. Salamat with the opportunity to come forward with unrestricted evidence and a defence, whilst at the same time holding that the summary judgment application against my client was made good, which therefore created the possibility, which came to fruition, of there being inconsistent treatment of the issue of whether there was a breach of contract or not, and specifically as to whether this 5% arrangement was or was not compatible with the terms of the agreement.
Which was a factual question. Therefore, your argument is that, as I understand it, that if you allowed evidence to be put forward, it could go to that
Yes,
matter.
my lord, that's the point.
It's not a point of interpretation of the contract.
And that's the difficulty, is that the learned judge essentially closed off the arguments against my client at a preliminary stage when the court was still going to be receiving evidence.
Well, no doubt, in fairness to the judge, he didn't imagine that there might be more factual material at that point. It wasn't precluded.
No, I fully recognise that there'll be significant sympathy for the judge in this position, but it is a risk that is taken by having the bifurcation. You have an evidential stage up to a point within the hearing, a determination at that stage where actually that issue is still live as against Mr. Salomon.
Where is it written down in any authority that it is an error for a judge to take a procedural risk? I mean, you see, the problem you face is that the judge actually did something that was not very, turns out to have been not very clever, right? We're being brutally honest. But that is a different thing from a ground of appeal. So can you show us your ground of appeal that is sustainable? Because it seems at the moment, to me anyway, to be quite open to Mr. Adamson to say, well, there isn't anything that he did wrong except what happened afterwards.
I think, my lord, the error is in creating a situation in which that possibility came to fruition. I appreciate it almost looking retrospectively at that scenario, but you have a situation in which...
Is there any authority for saying that judgment should be set aside because of later events show that it took a risk it shouldn't have taken?
There's a reference within Arnold and NatWest Bank, my lords, the House of Lords decision, which talks...
That's your ground one.
Yes, it's in analogy discussion about what happens if it turns out later on that a judge has made a mistake. My lords, that's within the Joint Authorities bundle.
Which page?
The judgment itself starts at page 2, but the relevant section is at page 18 through to 19.
Right, which bit?
It's from page 109F. I could ask your lordships to read through to 111 at B. There, the Lord Keith talks about special circumstances existing which might allow a previous judgment to be opened up where it is incompatible with a later judgment.
Well, it's a weird exception, isn't it?
It is, my lord, but it's also referenced at paragraph 46 in Virgin Atlantic, Lord Newburger, which is at the Authorities Bundle, page 690, paragraph 46.
Sorry? 90.
Page 90.
36.
Yes, 46, my lord, forgive me, paragraph 46. It's the reference that the learned judge below referred to within paragraph 45 of his second judgment.
Yeah. So what's your ground of appeal?
Ground of appeal is that the learned judge erred in essentially bifurcating the process of the summary determination of the summary judgment application by allowing in subsequent evidence on the point that was relevant to issue 1. And the special circumstances which I recognise are that you have a situation in which there's going to be a determination at the trial against Mr. Salamat as to whether there's a breach of contract including an argument as to whether he can argue that in circumstances where my client has been held to be...
What you actually say at page 16 of the core bundle is that the judge wrongly bifurcated the summary judgment process. His discretion was exercised in a way that was plainly wrong, as no consideration was given to the prejudice that might arise to you. The unequal treatment placed FMC at a disadvantage, breached the overriding objective and the court's duty to manage cases fairly, and he should have adjourned the entire hearing.
And my lord, in that context, the judgment 1 does record the fact that my client essentially is not the wrongdoer here. Because of the structure of the contract, it is liable, regardless of any fault on its part, if Billpay is in breach of contract. And the judge recorded the fact that these were matters at which my client was not responsible. That's paragraph 41 of judgment 1 at page 65 of the core bundle.
Okay. Right, well...
And also paragraph 52 of the core bundle, again within judgment 1.
Yeah, okay. Well, that's the way you put it.
Yes, my lord. If I could just take any further. No further submissions, my lord, unless I can assist further.
Anything else?
Can I ask one question?
Yes, of course.
Assuming there's no procedural irregularity, your ground 2, you draw attention to Arnold and Virgin Atlantic. If those decisions or the principles in those cases support your ground 1, how is it to be expressed as a ground of appeal if there's no procedural irregularity in what the judge did in J1?
It would have to be, my lord, in special circumstances in which a judge has determined two matters different.
I mean, basically, if I understand the argument correctly, I may have got this completely wrong. Under ground 1, what you're saying is there is fresh evidence, which, if it had been available at the time of J1, would have resulted in a different decision, and we can get around issue estoppel because of the special circumstances.
Yes, my lord.
So it's not as if there's anything wrong with the judgment as such, but it's a reliance upon fresh evidence combined with the hazily defined special circumstances. And
yes, my lord.
Yeah.
I can't put it higher than that.
Thank you.
Yes, Mr.
My lord, can I deal first of all with what I perceive might be a misconception about what is found in judgment 2 that might have emerged from the questions that we've heard? I think, my lord, the Master of the Rolls said fresh evidence came in. Mr. Salamat moved the goalposts and said, well, now it's a written variation. And that the judge said, well, that written variation case raises a triable issue and that can go to trial. And it is of real importance that is not what the judge found in judgment 2. So this is taking me out of order. What I'll do is just correct that misperception, perhaps answer some of the other questions my lords raised, and then I will go to the grounds as they're actually put, which is something that in my submission my learned friend was avoiding until the last moment.
So what did the judge find?
The judge found, if I could turn to the relevant part, which was 44 to 45 of Judgment 2. What he found was that there was a triable issue on issue 2, i.e. as to whether Mr. Salamat was liable for the breach of contract, his bona fides. He was invited, as is recorded in the judgment, by Mr. Cohen, KC for Mr. Salamat, to reopen the question of issue 1, i.e. whether there was a breach. And Mr. Chelmick, for Fastmove, said that the judge was not entitled to reopen issue 1. And the judge did not make any finding either on issue 1 as a matter of substance or as to his entitlement to reopen that issue. What he said was, I'm going to paraphrase and I'll take you to the wording. He said, there's a dispute as to whether I'm permitted to reopen issue 1. It's not necessary for me to resolve that dispute because if there is a triable issue on issue 2, then the application fails and I don't need to establish the other element of the tort of inducing breach of contract, namely breach of contract.
There's a triable issue on issue 2, and what?
And there is a triable issue on issue 2, and given that, it is unnecessary for me to decide whether it is permissible for issue 1 to be reopened.
Because the application for summary judgment fails anyway.
Exactly. That's what the learned judge found. So it would be wrong to reach the view that the judge has said issue 1 can go to trial.
No, but if he says that the case against Salamat can go to trial, he is saying that all the issues pleaded in the case against Salamat, including Mr. Salamat's case, can go to trial, and Mr. Salamat has pleaded, and he knows he has pleaded, that issue 1 was wrongly decided at the first judgment stage. So, whilst it's true that that's what he actually said, the effect of what he decided in judgment 2 is that the case could be reopened.
In my respectful submission, that's not correct.
Well, it is correct, because he allowed the pleadings to go to trial.
He allowed the pleadings as they were to go to trial because he did not reach a view as to whether he was entitled to reopen
Doesn't
issue
matter.
1.
That's therefore open, because he did not say in his order, which we've now been shown, that there is any limitation on what is to be tried.
No. And then the pleaded case raised in reply is there is a limitation on what is permissible to try, and that's something that will be an issue at the trial. So there's been no predetermination of that issue. That is a trial issue, which the judge found it unnecessary to determine at the summary stage.
Well, if it is determined at the trial that the issue 1 should be reopened,
Yes.
and should be decided in another way, that causes great injustice to FMC. And it is very unjust, is it not, that FMC should not be able to appear when that issue is being argued.
Well, my submission, if the judge reopens issue 1, the injustice would be on Fastmove, and it would be Fastmove's appeal from the trial. Because we would say that that's a breach of the principle of issue estoppel. You've decided this issue.
Well, we know what you say, but Mr. Buck says issue estoppel has an exception to it.
And whatever we might think the answer ought to be, we're not asked to, and we can't decide that issue in an appeal to which Mr. Salamat is not a party, can we?
No, and I don't ask your lordships to decide it now, but what it is important for your lordships to know is that the judge will be deciding that issue in due course with Mr. Salamat. If he is permitted to reopen that issue, well.
But how can you stand there and say that it is just for you to retain a judgment when different parties are going to be arguing that that judgment is wrong and not sustainable on issue estoppel grounds?
I'm not sure I followed the question. I can submit that it's just for judgment 1 to stand because...
Yes, but what if you lose? And why shouldn't FMC be that when you're submitting that the judgment should stand? FMC would like to say it's not because there's new evidence. The only just way of resolving this is to do away with this mess and start again and have a proper trial involving all the parties to the case.
Well,
I mean, my concern is not whether that is the only... I would have thought you would readily accept that that's the only satisfactory way of dealing with it, but you're going to say, I imagine, technically, that that's not open to the court for a number of different reasons. But as far as justice is concerned, it's obviously totally unjust and unreasonable to have a situation like the present, is it not? From either your point of view or his point of view or Mr. Salamat's point of view.
Well, in my submission, it's not, because justice needs to be looked at in the round, including the prejudice on Fastmove. And the context of this appeal is that it's brought 9 months out of time. And there is a real prejudice that falls on Fastmove for this court to decide late in the day, when the CMC and the trial against Mr. Salamat has happened, and disclosure is next month, and the trial is next year. There is an injustice to be balanced. Now, if this appeal succeeds, of course we will be saying that FMC should be joining that trial, and it needs to get its skates on. That will be our position. But there's no guarantee that that will be possible. And the other interests of justice that are at play is, first of all, the finality of the judgment that went unchallenged for 9 months. And second, the prejudicial effect on a party which has done nothing wrong, Fastmove, which was entitled to rely on the existence of a judgment, final and binding nature of judgment for 9 months, commenced enforcement procedures in Singapore, applied for and successfully obtained a post-judgment freezer against the appellant in this case and the evidence of dissipation, where FMC has not paid the judgment, has not paid the costs, although it obviously has funds to instruct counsel here today. And there is a real risk of disrupting the very trial where these issues are to be determined. And that's not the fault of Fastmove, certainly not the fault either of the judge on judgment 1, given what was before him then.
Well, it may well be shown to be the fault of Fastmove, because it may be shown that Fastmove was fully aware of all these WhatsApp messages and protocols and portals and all sorts of other dealings between Fastmove, Mr. Safi and Mr. Salamat, and it may be proved that the fraud, because it looks to me very likely that a fraud was committed in this case, I have no idea what it is because we haven't even given part of the documents, may well have involved all of the parties. You know, we've no idea. It looks, you know, without being, you know, we're in open court here, it looks a dodgy transaction. I've no idea of the legality of it. Mr. Buck says it's his client's got a license to do what his part of it, but I've no idea about the other parts. But you were involved, if I may say so, up to your neck, Fastmove, because you're sending suitcases full of cash to Singapore.
Well, my lord, it is important that I address that. We are regulated by the FCA.
To send suitcases full of cash to Singapore.
Cash, yes.
Right. Okay. Well, I'm very interested in that, but I'm
and
sure you're right. But you know, whatever regulation you do have, it does not look like a particularly usual arrangement to me.
But it has been raised in evidence twice in Judgment 1. It was raised by the respondents. Well, it's a compelling reason to go to trial that this may not be a legitimate business that we were involved in. That was the defendant's case. And
Yeah.
the judges rejected that. There is no evidence that what Fastmove was doing.
Sorry, who rejected that?
The judge in Judgment 1.
Right.
Which we can perhaps go to.
Well, show me. Yeah.
Yeah. It's paragraph 52 on page 67. Illegality is raised as a defence to the summary judgment application. And the judge finds, in terms, there is no evidence of illegality or wrongdoing on the part of Fastmove. The business is regulated.
Paragraph 60.
52 on page 67. Apologies.
The fact that there's no evidence of it doesn't mean that there wasn't any.
Well, but I would urge your lordships not to.
We know so little about this case. The judge may have known more. We don't. We haven't got half the evidence. But
Absolutely.
anyway, whether it's entirely legitimate, although I've never heard of such an entirely legitimate business, where did the cash come from? Your client's £40 million in cash. Who has £40 million in cash legitimately? What is it?
Well, my lord,
What is the business your client's involved in?
if I could turn your lordships to paragraph 6 of the reply, that sets out what we say the business is that we're involved in. So this is again to address the case raised by the defendants as to what, as to whether there's illegality. And we say, regulated by the FCA and HMRC to carry out money remittance activities, operates a business-to-business model. It only provides services to other businesses and doesn't transact with individuals.
I'm sorry, I'm asking a different question. What is the business that involves £40 million of sterling currency being transported to Singapore? What is the business model? What are you doing? Not that you're regulated, you've told me that. What are you doing in business terms? Who are you doing it for? Who wants £40 million of cash sterling transmitted to Singapore in cash, then translated into Singapore dollars, and then translated by Indonesian agents into US dollars, and transmitted back to accounts in Europe? Who wants that done and why?
Well, again, it's pleaded out. I mean, I do urge your lordships that your lordship has said.
Well, I'm just asking.
Well, the answer is set out in the reply. It's not in evidence yet. It's pleadings. It's the stage that.
Where is it set out in the reply?
So, the services offered is to other businesses, which is money service businesses. Those are businesses which. That's at 6.2.
What sort of businesses are the other businesses? I mean, this is what I'm asking. You know, I don't understand what sort of business undertakes this kind of transaction legitimately. That's what I'm asking. I would have thought it was fairly easy to explain. This is a business that sells sweets to children in return for cash, and they operate in England, but they have a burning desire to have their money translated into Singapore dollars and thence to US dollars, and transmitted back to England because X, Y, Z. I mean, there must be some reason for it.
Well, that's at paragraph 6.6, my lord.
6.6, yes.
So, money service businesses have cash in the UK, and they need to make funds available overseas to pay third-party invoices. And of course, one way that might be done is that it's converted to Singapore dollars in the UK, but the way that it is in fact done is the export of cash to Singapore, where it's converted, and that's the service, and then remitted.
Okay, well, I can't digest this lengthy explanation, which has only been put in just now, but not in the papers before this.
Well, my lord,
But all I'm asking is that seems quite likely that there is more to this story than either the judge or we are being told, and that therefore what I put to you is the justice of the case, leaving aside the procedural arguments that you want to raise about how it's late, the justice of the case is that it would be better for all the parties to be at a trial to decide who's right and who's wrong, and whether anything inappropriate was or was not done. Why is that not right?
well, it's for the reasons that I've already submitted, my lord. The justice of the case is, A, there was a hard-fought summary judgment application where the issue of breach of contract was argued by all parties and a final and binding judgment reached. The justice of the case now is that Fastmove is entitled to the benefit of that judgment, absent there being an error of law and an appeal brought in time. And the rump of the case that's going to be tried, the justice of the case would involve not disrupting that testing of that case.
Okay, justice of the case involves not disrupting the summary judgment. Okay.
I started by saying that I wanted to dispel the perception that issue 1 had actually been reopened by the judge, and that he had actually found. Can I pick up just one other point from paragraph 44 that my lord raised about the final sentence of 44, which is at page 51? And my lord said his case at the previous hearing was that summary judgment should not be granted because of the factual dispute about whether Billpay were entitled to withhold the money, and his first witness statement relied upon an agreement, but there was a 5% fee. And my lord queried, well, there wasn't a factual dispute at judgment 1, but in my submission, the construction of that sentence is that he is saying that Mr. Salamat's case was that there had been an oral variation, such that that raised a factual dispute as to whether that oral variation had taken place. And the judge held it was irrelevant because an oral variation wasn't permitted. The next sentence of 45 is extremely important, and it was the focus of my learned friend's submissions. He said, there may be an interesting argument to be had. And what my learned friend submitted was, the meaning of that sentence is, there may be an interesting argument to be had on issue 1. I.e., this is the judge saying, issue 1 can now go to trial and we can have argument about it. But that's not what that sentence means, and that's clear from the context. It comes after paragraph 44, which is where the judge said, that was in litigation to which Mr. Salamat was a party, and followed the hearing of an application where he put in evidence and of which he was represented. That follows a sentence where Mr. Chalmik has submitted that this issue has been determined, the judgment given. And so the interesting argument to be had is whether there is an entitlement to go behind that judgment. And that's clear from then the 3 sentences on in paragraph 45. To what extent did that leave it open to Mr. Salamat to continue to argue the merits of what the parties have referred to as issue 1? That is the interesting argument to be had, that question there. And that's clear from that context. And as one can see there, Fastmove has admitted that that issue is closed for reasons of issue estoppel. Then the judge says, well, I'm not going to decide that issue of issue estoppel now. And the point was, because the point was not explored in any detail, essentially because to succeed on issue 1, Mr. Salamat would have to succeed on issue 2. And since issue 2 raises a triable issue, I don't need to decide, not only do I not need to decide issue 1, but I don't need to decide whether issue 1 has been closed. And then the state of the pleadings, as I've said to your lordship, is after this the amended defence goes in and the reply goes in saying that the judge, the case which Mr. Salamat seeks to raise in his amended defence, he is not entitled to raise. And that's the issue that will go to trial. And if I could just compare those conclusions to the way the appeal is actually put in the grounds, and take your lordships to both grounds. Ground 1, which is at page 15 of the full bundle. And what's key about ground 1 is that it said that this interpretation, i.e. the interpretation of the banknotes agreement in Judgment 1, was later contradicted in Judgment 2, where the same judge accepted that. So the following are said to be findings in Judgment 1. Call-off contracts defined as orders could be formed orally or via WhatsApp and confirmed through a portal. And just pausing on that one, as courts already pointed out, Mr. Salamat's case, even Mr. Salamat's case, is no longer that orders could be formed orally. So not only is that not something the judge found, it's not something that Mr. Salamat even advances now. The second point is the portal contained written references to fees 5% and showed Fastmove's director accessing it. It's said to be a finding of fact actually made. And finally, the 5% fee arrangement was consistent with the express terms of the banknotes. So, i.e., the judge has reached a conclusion on the construction of the contract and has found that the 5% fee arrangement was consistent with it. And in my submission, it's plain from the section I've just taken, your lordships, that's not something that he found. In fact, there are no findings of fact in Mr. Salamat's favour in Judgment 2, and it would be surprising if there were, because Judgment 2 is a judgment on the claimant's summary judgment application, which was rejected because Mr. Salamat raised a triable issue on the facts. So there are no findings of fact about a director accessing a portal. And that's these are the propositions on which this appeal rests.
Would it be solved if, instead of saying where the same judge accepted that, A, B, and C, it said where the same judge accepted that there was a triable issue whether A, B, and C? Is that really the point you're making?
Well, it wouldn't be solved. In that case, there would be no still no contradiction between Judgment 1 and Judgment 2.
No, but there's a contradiction in Judgment 3, a potential contradiction in Judgment 3, the one you're having next year. And I don't see how you can rebut that.
Well, I accept, my lord, that if, impermissibly in our view, the judge reopens the question of issue 1, if the case that Mr. Salamat seeks to advance, which we say is fraudulent, survives the process of disclosure and evidence, and if the judge is required to decide issue 1, because of course the judge isn't required to decide issue 1 at trial, for Mr. Salamat to escape liability, essentially for the same reasons as he wasn't required to decide issue 1 for the summary judgment application. Because if Mr. Salamat establishes that evidential case as to his honest belief as to the operation of the contract, then that's the end of the claim against him. And the judge won't need to reopen issue 1. So, if...
He won't need to, but he's being asked to.
He is being asked to, my lord, and we would resist that when the time comes.
But you may lose.
I accept that, my lord, and then there would be an appeal.
Well, you can appeal to the Supreme Court, but you may lose. And if you lose, there is an essential injustice against FMC.
I don't accept that there would be an essential injustice because it arises from a late appeal and a failure for the defendants to advance the whole of their factual case at the relevant time.
That's a different point. You may be right about that, but that's a different point from the one I'm raising. You seem to resist the idea that there would be an injustice if a judgment has been granted against FMC, which a later court decides should not have been granted because there was no breach of contract. And I don't understand how you can resist that. I can see how you can say you should accept that possibility of injustice for the following 7 reasons. I completely understand that. What I don't understand is your resolute determination that that would be perfectly okay.
It may be, my lord, that there's a distinction without a difference in the use of the word injustice between us. What I accept is there is a possibility of what often happens in issue estoppel cases, which is that an issue is determined as between A and B, and then the same issue is determined as between, say, B and C, that the 2 judges reach different views. Now, on one view, one of those answers is wrong. Is it an injustice? In my submission, no. That's the way that litigation works. The determination as between B and C makes no difference as to the rights between A and B inter se. And the court is well used to living with situations where A says, well, I wish this other evidence had been before the court when it was disputed
You
between
may
us.
be right, but let's really where this appeal comes down to is not round 1 but round 2. Because really what it comes down to is whether the judge made an error in bifurcating the thing in the way that he did and giving Mr. Salamat the opportunity to plead anything and put evidence in about anything so as to create this situation. And Mr. Buck says he did.
I can go to ground 2 now, or I can finish on.
No, you finish or take your submissions as you think best.
Well, on the second bullet point, B, which I believe I haven't addressed you on yet, the portal contained written references to Feed 5% and showed Fastmove's director accessing it. Your lordships will have the point that that is not what the judge found. In fact, the judge was very sceptical of the veracity of the evidence.
Well, he was, but he gave permission to defend on the basis of it.
That's correct, but that's far from an actual what this ground of appeal
Well,
system
we've got that point.
Yes, we've got it.
My lord pointed out to you that it's obviously not correct to say the judge accepted anything in a summary judgment application.
Yes.
What he did was find a triable issue.
Yes. On issue 2.
Yeah. But he also gave him permission to plead issue 1 again.
Well, he didn't. Issue 1 was already in the pleading. What he didn't do was strike out issue 1. That's
Exactly.
correct.
In fact, he said in the order, because we've got it now,
Yes.
he said he gave permission to amend, to plead that there was no breach of contract.
Oh, no, it's already. The permission to amend there was not in respect of breach of contract. What's already on the table at the time of judgment 2, which one can see from the judgment, is that Mr. Salamat has raised that there was no breach of contract and sought to re-argue it already.
Yes, but he's got permission to amend, to provide an amended defence which contains the plea that there's no breach of contract.
That's correct, and that amended defence addressed the rest of the claim, i.e. other than the inducing breach of contract. But I accept, of course, my that pleading is still there on the face of it. Right, ground 2. Now, on its face, on the basis of the first sentence, ground 2 is that following a series of procedural irregularities, the most notable of which was Fastmove's failure to properly plead fraud, the learned judge bifurcated the summary judgment process, granting summary judgment against FMC. So that appears to be, on that first sentence, the point that your lordship's pressing on me, which is, well, wasn't it wrong? A bad case management decision from the get-go. And your lordship pressed on my learned friend, well, doesn't that have to be your appeal? And I would agree with my lord that is the way which Mr. Buck would need to put the appeal in order to succeed. But it's not put that way, and the reason why it's not put that way is because of delay. Because if this were an appeal from a case management decision, which from the moment it was made gave rise to a risk, and that's Mr. Buck's point, then that is an appeal which could and should have been brought within 21 days of that case management decision being made. And my lords, I had that been brought in that way, we would be saying, well, it's a case management decision, it's an adjournment, that's within the...
Don't touch it.
Yeah, don't touch it. But that's not what was done. And the reason is that ground 2 is, in fact, well, what was left was for a very long time. So Mr. Salamat files his defence, he files his evidence, there is a hearing, and then eventually we get to judgment 2. So what the appellant needs to do is to try and squeeze ground 2 into the box of an error which only emerges once judgment 2 is handed down in order to answer the timing point. And one can see that from 6b, where it says that the learned judge effectively created a two-tier standard where Mr. Salamat was able to file a full defence, adduce new evidence, and re-litigate issue 1. And that's the point which I tried to show your lordships the judge has not done. He has not decided whether Mr. Salamat is permitted to re-litigate issue 1.
Well, that's what the judge did create. I mean, whether you call it a two-tier standard, but he created a situation where Mr. Salamat was able to file a defence relitigating issue 1 when they say he shouldn't have done.
Well, he has filed a defence where he has asserted he is permitted to relitigate issue 1. And in my submission, that's an important distinction. But your lordship has that point.
So you say that he should have brought the appeal in 21 days from the first judgment?
Yes.
But at that stage, realistically, would he have been able to deploy the material now being deployed?
Well,
which only became available in connection with the second hearing leading up to judgment 2.
Yes, well, I have some submissions on that, my lord.
I mean, this comes down to the dashboard point, doesn't it? 5 references to the dashboard, if I've got it right.
Well, it depends on how the appeal is. I'll answer your lordship's question now. I will take you
In
through
practical
the chronology.
terms, that's what we're talking about.
Well, in practical terms, there's various different ways in which the appeal could be put. The first is that from the moment the court adjourned, there was a risk that Mr. Salamat would then adduce evidence which showed that Judgment 1 was wrong. If that's the way the appeal is put, that can be put from the day
Yes,
Judgment
it
1 was
could, but it'd be
entered.
highly speculative. You'd have no idea what would be coming forward additionally.
Well, as I would respectfully adopt an observation of the Master of the Rolls that there is no appeal from a risk, from a case management decision which gives rise to a risk. There's always a risk that that material would emerge. And so I suppose the question for your lordships is an appellant entitled to wait until the risk materialises before bringing an appeal substantially out of time?
Well, I mean, this is a very unsatisfactory case in a whole range of issues. But what I would like to focus on is whether the judge made an error which is appealable.
Yes.
And if he did, then we can, I mean, if he arguably did, or there's a case that he did, we can then address the question of whether the delay in bringing that appeal in respect of that error is unjustified, justified, or should be the case of relief from sanctions or all the other things that people get completely obsessed by, but actually only arise if the judge made an error. Now, at the moment, as I understand it, you're addressing the question of whether the error alleged against you is truly an error which is a sustainable appeal.
Well, at the moment, I'm addressing the question of what the alleged error is. And the submission I'm making is that the alleged error has been crafted in such a way to avoid the timing question. So the two aren't as neatly separated in this appeal as might ordinarily be the case. And the submission I'm making to your lordships is that if the error is asserted, is that it gave rise to a risk that Mr. Salamat would adduce further evidence in the question, which is a risk which I would submit was obvious from the day of Judgment 1. If that is the alleged error of law, there are timing problems, but it's not the alleged error. And one can see that from the way that ground 2 is put. So if your lordships hold my learned friend to the grounds, the alleged error only arises from the moment of an inconsistent finding sometime later, which was not there.
Which is not yet there. There is a possibility of an inconsistent finding, but there hasn't been one yet.
There is a possibility of what we would submit to be an incorrectly found inconsistent finding. But yes,
Well,
yes.
I mean, incorrect or not, if it's found, it will be correct. It will be relying upon an exclusion, an exception to the rules of issue estoppel. But who knows what the judge will find. But there is a possibility of an inconsistent finding because of the pleadings the judge allowed to proceed.
I accept.
You accept that?
I accept that.
You have to.
Of course.
Yeah.
And then I moved to the submission I made a moment ago, is that inconsistent it would be wrong, but inconsistent findings are a feature of litigation where issue estoppel does not apply.
Well, you've made that submission.
Yeah.
What I don't understand is why you say that the error alleged in the ground of appeal is crafted to. I mean, I understand why you want to place great reliance on the 9 months delay. I get that completely. I don't understand why you say they've said something different in the second ground that they would have said if they had not had a time delay. Because it seems to me the second ground, I mean, subject to the point my lord made, the second ground is just saying there is a possibility of an inconsistent finding which will give rise or would give rise to prejudice to FMC and put them at a disadvantage, and he shouldn't have managed the case like that.
it's all about what the judge is said to have done wrong at the stage of judgment 1.
I agree that that's the way the ground should have been put.
No, it is put.
It is put, yeah.
He should have adjourned the entire hearing. Paragraph 9. He bifurcated the summary judgment process. Paragraph 6. That all happened at the stage of judgment 1.
Yes. Well,
Should have delayed passing judgment on all parties until Mr. Salamat's case has been fully dealt with,
yes.
which is what Mr. Buck is saying. He's
Yes.
saying, look, it's not fair to me because I've got a judgment against me and it all may all turn out differently.
Well, there is, in my submission, a constant equivocation both in the grounds and in the skeleton as to whether this is an appeal brought because of the injustice from the case management decision alone, or arising from the emergence of evidence, which, by the way, is not before this court.
Well, you have to see it from FMC's point of view. FMC says they had no idea that there was a side deal, right? That's what Mr. I'm sorry, I can't remember his name, Jalaluddin says. No, I'm an old bloke who sits in a very small cabin in the Orchard Road shopping centre. I had no idea that Mr. Safi and Mr. Salamat had cooked up this deal whereby they were paying a percentage. All I thought was that I was doing this deal and getting some small profit by arbitrage, and that's what I do for a living, so there we are. And I didn't know then. I saw, of course, he says, the 5% defence in Mr. Salamat's original affidavit, but I didn't think much of that. I mean, I'm making this up as a sort of story. Didn't think much of that at the time because I knew nothing about it. But if it turns out to be true, then I'm very badly treated. True?
Oh, I see that way of putting the case, my lord.
Yeah.
But if
That's
the way,
the way he does put his case.
well, in that case, we are very much in the territory of delay, because if he feels he's been badly treated and it just emerges when he sees this evidence, then...
Well, I mean, you may be right about delay.
Yeah.
I mean, obviously he has to get over delay.
Yeah.
But I mean, it's all I'm really keep on putting to you.
Yes.
If you walked in and said, Mr. Adamson, this is a tough case, right, from poor old FMC's point of view and Mr. Jalaluddin. But tough cases exist, and the judgment was properly given in the first place. There was a case management, something that other judges might not have done in a case management situation. But it's not really an error that this court will interfere with, because we don't do that to case management decisions normally. So it's tough. Maybe tough, but it's tough. That I would find more attractive. Maybe, whether it's right or wrong, I don't know. But,
well, my lord has summarised the position more elegantly than I have, but I think I have, in essence, made those points. That it is a tough case. It's the same kind of tough case in that scenario, where, as I said, there is an issue of estoppel, and the court reaches different conclusions on the basis of fuller evidence in the subsequent case. And that's tough on A and B, in my example.
No, I mean, look, of course you're right. Of course you're right. There are cases where there has to be a tough outcome.
Yes. And what your lordships are here doing, and this I accept it's also going to the timing point, because of the delay, your lordships are balancing, if that is to be categorised as an injustice, your lordships are balancing injustices to Fastmove, which has also been the victim of Mr. Salamat bringing forward a new factual case late.
Well, except that, I mean, the difference between Fastmove and FMC is that Fastmove seems to have been party to materials that mention such a thing as 5%. I mean, that's putting it perhaps too high, but it's possible. FMC definitely seems not to have been.
Well, actually, my lord, on that point, that's not correct.
That's not correct.
The materials to which Fastmove was a party which mentioned the 5%, those are the WhatsApps.
Yes.
Those WhatsApps were provided with initial disclosure back in May 2023.
No, I mean at the time.
At the time, correct. But by the time evidence is filed by FMC a year later, FMC has all of those messages.
Right. But I mean, my point is not about how this has all emerged.
No.
But my point is, at the time, it appears that nobody suggests Fastmove knew about the 5%. The Fastmove was doing a very isolated
FMC.
part of this extraordinary transaction, concerned with bag loads of money. But that's all it was doing. I'm sorry that I sound so offended by these bag loads of money, Mr. Holmeston, but I'm afraid I'm an old judge, and that does tend to make people a little suspicious when cases are about large quantities of cash.
I accept that, my
Crossing
lord, and
continents.
you can see that the judge was, you considered that already. And
Well,
I would
he did.
really urge your
He did.
lordship not to have in your minds what your lordships have expressed as sort of a whiff, which actually
Whiff,
has already been considered by the judge below
Yes.
and is not challenged on this appeal. Your lordships can only fairly proceed on the remaining at least neutral on that question.
Yes. Well, I take that point. We're not being asked to decide the whiff issues. But they may be very whiffy, nevertheless.
Well, I respectfully disagree, but I hear your lordship. Okay, so we were discussing, your lordship said, well, FMC and Fastmove are in a different position because Fastmove is said to have known about these references to 5%.
Yes, that's the point.
There are two categories there. One is the references to 5% in WhatsApps. And my submission is those, FMC had those a year before it filed evidence on summary judgment.
Right, but you're addressing the procedural question, and I'm addressing the substantive question.
Yes. The portal is difficult because we, of course, say it's fabricated evidence. So our position...
You say it's all fabricated.
We say it's fabricated, yes.
The WhatsApps.
No, not the WhatsApps, the alleged portal. So there's WhatsApps where the exchange rate was agreed. That was before the court on Judgment 1. And there are some references to a 5% fee in those WhatsApps.
The portal.
Sorry, no. Sorry. I apologise. There's a reference to a dashboard in some of those, which later morphs into the portal.
Yeah.
What there isn't in Judgment 1 is reference to the portal. And the reason we say there's no reference to the portal is that it's fabricated evidence. And your lordships have seen the IP addresses, which are said to evidence that a Fastmove director accessed that portal. And the judge considered, well, those IP addresses are, in fact, the first two results to a Google search for IP addresses in Birmingham, which is where Fastmove is based, but that it raised a tribal issue. So from the perspective of the portal, our case is that FMC and Fastmove are in the same position in that neither of them had access to something which doesn't exist. And from the perspective of the WhatsApps, everyone was on a level playing field.
After the event.
From the moment proceedings were issued, yes. And then finally, final point, everyone was definitely on a level playing field from the time of Salamat 2 was filed, which is before the hearing which led to Judgment 2.
The Salamat 2 doesn't say much more than Salamat 1, except to deal with the dashboard portal.
Well, it says quite a lot more. It's 60 pages long. A lot of it is recorded in Judgment.
Substantively, I realise it's very
Substantively. Well, it sets out many of the steps that are said to have
chapter
gone.
and verse.
Yes.
Anyway, there we are. We're not conducting a trial, mini or otherwise.
Lords, I have submissions on extension of time.
Yes, I mean, important that you make those.
Yes. Whereas your lordships have the judgment one's handed down 14th of November 2024. No application for an extension of time, so that's when the 21 days began to run. And the application for permission to appeal was made on the 15th of September 2025, i.e. just over 10 months later. So that's 305 days by my calculations, so over 9 months late. And those 10 months can be divided into 2 different time periods, which raise different considerations. There's what I will refer to as period 1, which is the time between hand down of judgment 1 on the 14th of November and judgment 2 on the 11th of July. That's around 8 months. Period 2 is the time between judgment 2 on the 11th of July and the 15th of September, which is when the appellant's notice was filed. And that period is 66 days. So even if this were an appeal of judgment 2, it would be brought 45 days out of time. Of course, there's no strict deadline after judgment 2, because this is not an appeal from judgment 2. But I believe my learned friend and I are agreed that 21 days serves as a reasonable benchmark for what's prompt in the circumstances.
It wasn't prompt.
We may not be agreed, but in my submission, 21 days serves as a benchmark for what's prompt, and the witness statement of Mr. Farag, which goes to delay, takes 21 days from judgment 2 as a benchmark. Now, there are cases that there's been delay in both time periods, albeit for different reasons, and either delay it's submitted is individually sufficient to refuse the application to extend time. Now the reasons for the delay, which is stage 2 of the Denton test, are different in each period. So I'm going to deal with them separately, and then I'm going to make submissions on discretion compendiously.
Yep.
I don't think I need to take your lordships to the authorities on extension of time. Your lordships will be aware the leading case is Hysage, Denton test, 3 stages. We do rely on some other principles from the judgment, which I don't think will be controversial. The first is that shortage of funds does not provide a good reason for delay. It's paragraph 43 of the judgment. And second, that the merit...
Paragraph 43, which judgment?
Of Hysage. I can take your lordships to that.
Yep.
The second is that the merits are generally irrelevant. And perhaps I should take your lordships to that. That's at page 306 of the authorities bundle. If your lordships are working electronically, I think the internal pagination is slightly off from the PDF. It's page 309 of the PDF. And that's 46. It says, if applications for extension of time are allowed to develop into disputes about merits, they'll occupy a great deal of time. In most cases, the merits of the appeal will have little to do with whether it's appropriate to grant an extension of time. Only in those cases where the court can see without much investigation grounds of appeal are either very strong or very weak, will the merits have a significant part to play when it comes to balancing the various factors. And the final principle, which in my submission will be uncontroversial, is that the longer the delay, the less willing the court should be to extend time. We also refer in our skeleton argument to the case of Smith and Brough, which is a decision of the Court of Appeal, 2006 Civil Procedure Reports at 17. And that's the judgment of Lord Justice Brooke, which sets out the issues of public policy relevant to the exercise of discretion. And that's at page 235 internal, 238 of the PDF.
Yeah.
From time to time, this court is receiving applications for permission to appeal, which include an application for a long extension. In agreeing that this application be dismissed, I wish to stress 3 matters. And those are: 1, that it's a fundamental principle of common law the outcome of litigation should be final. 2, that the law exceptionally allows appeals out of time. 3, that this and the other exception mentioned in that passage are the exception to a general rule of high public importance and reserved for rare and limited cases, where the facts justifying the exception can be strictly proved. And then one more case and one more principle, and that's the case of Yates and Aviva Insurance UK Limited. And that is at page 248 of the PDF, 245. And the principle is that on an application to extend time, there is an obligation on the appellant to be full and frank with the court.
Yeah.
And this is a case in which we say that the appellant hasn't been full and frank with the court. In terms of the delay, the most efficient way to take your lordships to that is by the reference to the agreed chronology, which is in the what's labelled as the unagreed bundle at tab 15 from page 228, but the chronology itself is agreed. And there has been a history of delay in these proceedings, which in my submission is relevant. So proceedings started in Singapore back in 9th of November 2022, and that was worldwide freezing injunction against Billpay and FMC. In answer to your lordship's questions earlier, Billpay is a company limited by...
Billpay is a company.
Billpay is a company. Mr. Salamat was a director until he resigned.
Singaporean company.
Singaporean company. And FMC is also, well, it's what's called a sole proprietorship that has the effect of being a sole trader in England and Wales. And that's why the post-judgment freezer was against Mr. Jalaluddin personally.
Yes, but the sole proprietorship, I mean, I've come across them before in Singapore, is just a fact that a sole trader in Singapore has to register with the authorities and say, I'm a sole trader. Whereas in the UK, you don't have to register if you're a sole trader. But it has no consequence. It's an individual.
Yes.
Yeah.
Yeah. And that was the basis on which the freezer was against Mr. Jalaluddin personally.
Of course it was.
So, yes, Mr. Salamat resigned as a director of Billpay shortly after the freezing injunction was...
And does Billpay have any... It's not in insolvency procedure of any kind?
As far as I know, it's not trading. I don't know if it's in any formal insolvency proceedings. It's not, that we're aware of.
But does it have other officers or anything of that kind? I mean, is it a one-man company, or is it a company that might arise from the ashes?
I don't know the answer to that, but it was when Mr. Salamat resigned, and this is recorded in the chronology, he was replaced by a different director. So that wasn't the end. That's in the third line of the chronology.
Yes, I saw that.
Yeah. So proceedings commenced in January, served on the 3rd of May 23. In my submission, a material date in the chronology is that 1st of July 2023, and that was the date on which was the deadline for FMC to acknowledge service, and that passed. And the reason why that's significant is because, of course, from then, Fastmove was entitled to judgment in default. And it's one of the ironies of this appeal that the summary judgment is being so hotly fought, when in fact for a year, well, until the summary judgment application was filed, we were entitled to judgment in any event.
You didn't want judgment in default?
No, we didn't for enforcement reasons, and so we didn't apply. But nonetheless, that's what we were entitled to. Summary judgment application is then made with permission on the 30th of November 23. In the meantime, Mr. Salamat and Billpay are found guilty of contempt in Singapore. And it's not until the 21st of April 24, so nearly a year after proceedings were served on FMC, that it acknowledges service. And its first act is to apply for an adjournment of the summary judgment hearing, which has already been listed for April 2024, in order to give it time to file its responsive evidence. And it was granted that, so it had plenty of time to file its evidence. And the hearing is relisted for some time later on the 14th of October.
Yeah.
By consent, yes, in response to the application. And your lordships know, 14th of November, so it's judgment 1. So time to appeal expires on the 5th of December 24. It's not in the chronology, but it is in the bundle that the order on 24th of March 2025 that FMC is ordered to pay the costs, which have been summarily assessed at £78,000, and it's not paid those costs or the judgment sum, despite participating and paying representatives for today. The next significant date is the 16th of April 2025, and that is the date on which Mr. Salamat files his evidence on the portal, and he files a defence seeking to reopen the question of breach of contract on the basis of this new portal case. And as my lord said, he moved the goalposts, in that the new case is that there was effectively a written variation of payment terms through approval through the portal.
Yeah.
So that's the 16th of April. 14th of May is the hearing itself. Judgment to 11th of July, and then 21 days after that is the 1st of August. So if that's the promptitude, that's the day that we say, if judgment 2 is the key, we say the appeal should have been brought on the 1st of August, by the 1st of August at the latest. On the 23rd of July 2025, as part of the enforcement process of Judgment 1, a post-judgment freezing order was granted against Mr. Jalaluddin in Singapore on the basis of evidence of asset dissipation. And on the 11th of September, Fastmove commenced enforcement proceedings and issues an application for recognition and enforcement. which are now stayed pending this appeal. And then it's not until 4 days after that application for enforcement that the application for permission to appeal was filed.
So, I mean, the real delay, you say, is the period from the second judgment, second order, which is August, or July 2025, or 21 days from that, which is the 1st of August, whichever you prefer, to the 15th of September.
That's an important delay, and it's one of the two.
Absolutely huge delay.
It is a huge delay.
It is huge.
It is I would submit it is a large delay. It's 2 months.
It's what it is.
And we'll come to the reasons for it in a moment. But I do make 2 points about period 1 as well. The first is the one that we've been previously debating, and that's insofar as this appeal is a complaint that the judge should not have decided the claim against FMC, while giving Mr. Salamat a further opportunity, then time for that is judgment 1. Alternatively, if, as the complaint is sometimes put, it's that Mr. Salamat's evidence is not evidence that previously could have been available to FMC, and the evidence reveals that it was unjust to adjourn because of the new case, then the date for bringing that appeal is when the evidence is filed, the 16th of April, or at the latest when that evidence was ventilated, together with all of the other arguments.
Well, how did FMC know about the evidence that Salamat filed when their case was over?
Well, it's not in evidence whether they still could have accessed the court file, but what is in evidence is that they attended the hearing.
They attended the hearing, but that was in July.
The hearing was in July. No, sorry, it was May.
Oh, May. Oh, it's May, yeah. Sorry.
So it was only very shortly after this evidence was filed.
Okay. In what capacity did they attend the hearing?
I'm going to come to that, my lords. But they say it was Mr. It was FMC's solicitor.
It's what?
FMC's solicitor,
yes.
Mr. Farag attended, but he says he attended without instructions to do so. He attended remotely. And my learned friend said he wasn't instructed at that point in time.
Yeah.
And then...
Curious and curious,
yes.
one might say.
And the other point to make about attendance is, a primary case is that if this is about the evidence, about the arguments being raised, and FMC's solicitor was there at the hearing, then that's the moment at which, the very latest at which this appeal could have been brought, in the very terms in which it's brought. But the other point to make is, even if the court's not with me on that, the fact that FMC's formally instructed solicitor attended the hearing should colour the court's view of how promptly it could have acted when Judgment 2 was handed down. Because, of course, they know that Judgment 2 is on the way, they know what the arguments are that have been run, and what the judge is going, which are recorded in great detail in the judgment. And so they're well aware, from 14th of May, as to what's coming down the track. Can I turn to the factors relied on by by the appellant for an extension of time? That's in the skeleton argument.
In their skeleton?
In their skeleton argument, core bundle. Tab 3, page 26. In my submission, these are transparently weak grounds on which.
So which paragraph?
39, page 26, and there are 6 subparagraphs which set out the points. First of all, it says that FMC was previously excluded from key communications and lacked knowledge or access to the portal and WhatsApp group where fee arrangements were discussed. My Lord has touched on that already, and I've explained there is a distinction between the portal and the WhatsApps. The WhatsApps were disclosed to FMC with the particulars of claim. The portal, on our case, doesn't exist, so I don't contend that they did have access.
They were
to the
excluded.
portal. Yes, exactly. But the point there is that the portal was brought up in evidence by Mr. Salamat. And in the hearing at the latest. B is, while the delay is not trivial, it's justified by the emergence of His Honour Judge Worcester's findings as to the new evidence adduced in Judgment 2, which directly contradicts the findings in Judgment 1. And that's why I said earlier that the grounds are tailored for this point, anticipating this point. And in my submission, that's wrong. They're not justified because there are no contradictory findings in Judgment 2. C, my learned friend's predecessor refers to two cases, a single case, which is itself referred to in Arnold and Westminster. Could I take?
I mean, these are very different cases.
They're very different cases, and I can make that point shortly.
Yeah.
But
I mean, there is a point in D that there was no real prospect before the judgment, and
yeah. So
do we need to look at Rami Farag's witness?
We do. We absolutely do.
Do we?
I'm afraid so.
Which page?
Right. That's in the supplementary bundle. Tab 4, page 56.
Doesn't have a very good index, the supplementary bundle.
My Lord would have preferred the exhibit to be broken down.
So this is your solicitor, is it?
No, Mr. Farag is FMC's solicitor.
FMC, right.
So this is the witness statement on which the appellant relies.
Yeah.
To extend to. And so first of all, if we could go to paragraph 9.
Yes.
And this is the first point that they make.
So he's the solicitor who attended remotely without instructions.
Yes.
Yeah.
But here's the witness statement, and this is what came in with the application for permission. Mm-hmm. Nobody was instructed to attend the hearing leading up to Judgment 2 on the 14th of May.
Well, that's officially true.
Well, yes, but it's not full and frank. It's not full and frank.
Yeah.
And that's the point. So we had to write a letter.
He admits that now.
He admits that now, following us providing to them Mr. Farag's email to the court requesting that he attend.
Yes.
Right, I won't take your lordships today.
Yeah.
So the point my learned friend's just made about him not being instructed is new to me, and I'm told by those behind me that there's no notice of change of legal representative prior to the hearing. Yes, well, that's so yes, the email we had to dig out was at. I won't tell your lordships to it. No, I will. It's the unagreed bundle, page 174.
Yes.
Yes. So
Sorry, page.
174.
Thank you.
So this is the email that we then had to dig out. And then we had to write a letter saying, please confirm that you did attend. And then that results in the letter at page 179 from FMC's instructing solicitors. And he says, and they confirm that he did attend. Just ask your lords to read that.
Oh, this is for learning purposes.
Yes. And we're not told when Mr. Farag was re-instructed, but what we're told at the bottom of that page is that he did not read any material relating to the hearing before or after, and was only aware of the significance of the new evidence following consideration of the judgment. We're not told when Mr. Farag was re-instructed.
It's all pretty unedifying, isn't it?
Yes, and it's not full and frank. That line in that witness statement is not full and frank.
It isn't a witness statement. He's instructed on the 1st of August.
Ah, okay, first of August.
Yeah.
Apologies.
I suppose one of the things he would have learned at the hearing were all the powerful points made by Mr. Chelmick about the implausibility of the new evidence and the issue estoppel points,
Yes.
from which he might have deduced that it wouldn't be very sensible to press the button on appeal straight away.
Well, there's 2 points to make about that, my lord. The first is that that's not what Mr. Farag says. What he says is he didn't appreciate the significance of the evidence. So he didn't say, I did appreciate the significance, but decided to wait. And the second point to make is that there must at least be, he's well aware of that debate, and that's the point. And it's the permission to reopen the debate is the complaint, and that's what was ventilated. Well, if I could turn back to Farag 1. So we were looking at paragraph 9. Sorry, if your lords could keep this correspondence. Well, we'll go back to this letter, the other page, but I need to put the other page in context again by reference to the witness statement. Paragraph 10. I became aware of Judgment 2 being handed down several days after the 11th of July. After having read it, I spoke with the principal of FMC, Mr. Jalaluddin, and advised him that there may be scope of appeal. Judgment 1. So, paragraph 10, the first line, seems to be making a point that he wasn't aware of it straight away, which is going to feed into delay. Then if we turn back to that letter, which is in response to a bit of pressing from PCB Byrne, now we're looking at page 180. Paragraph 3, please advise on what date Mr. Farag obtained a copy of the judgment. In fact, it's confirmed that he was sent the judgment on the day, but he didn't read it until after the weekend. So, 2 point, again, that's not full and frank, but also this several days, it was just sat on over a weekend. There's no justification for extending the time on that basis. And then paragraph 4, please advise on what date Mr. Farag spoke to Mr. Jalaluddin. They spoke on the 16th of July, and that's the date on which Mr. Jalaluddin was advised of potential grounds of appeal arising from the judgment. So that's, on any view, that's prompt. That's 5 days after judgment is handed down, and it should be possible then to formulate an appeal promptly after that, but that's not what was done. And the subsequent delay is explained in the section headed explaining the post 11th of July delay. It's accepted that the appeal should have been made promptly in the circumstances. The first point is made at paragraph 16. The appeal application requires encyclopedic knowledge of the legal, factual and procedural history of this matter, made it prohibitively expensive for Mr. Jalaluddin, who's been suffering from financial issues, to instruct a team within the firm to act on it, because doing so would require significant reading in time from other lawyers. So it's been entirely dependent on Mr. Farag. 2 points I would make about that is, well, first of all, lack of funds isn't relevant. Second, there's a full team here. It's the second counsel that's been instructed on the appeal. Third, there's an obvious failure to delegate there. And fourth, it's just factually wrong that this is dependent on solely on Mr. Farag, because counsel's name is on the skeleton argument, as well as Mr. Farag. Both of their names are on it. So again, we don't accept that it was dependent on Mr. Farag for financial reasons, both because those are illegitimate reasons, but also it's just factually wrong. The next paragraph is 17. So this is the next justification for delay. I was on a pre-planned annual leave from the 5th to the 11th of August. And I would just point out, first of all, that 21 days expired on the 1st of August, so Mr. Farag has gone on holiday 4 days after what I submit is the deadline.
Well, I'm sure you're sympathetic about the food poisoning.
I'm sympathetic about the food poisoning, but again, this is not full and frank about it took me almost 2 weeks to recover from. I mean, what does recover from mean? Does it mean it wasn't working for 2 weeks? Is this a real justification for a further 2-week delay? Don't know, but the holiday in itself isn't any event's justification.
I mean, we can cut a long story short. You say this delay was unconscionable, it was too long, they knew about everything they needed to know about and they should have got on with it, and they didn't.
Yes, and they haven't been full and frank with the court about why they didn't get on with it. And
well, they've accepted most of the points you
yes,
made.
when pressed in correspondence, yes. And what's absent from this is any positive case, which is what one might expect. This is we were cracking on. This is what we were doing. The next paragraph, I will cut through it then in light of your Lordship's question. The next paragraph is all about language restrictions, time differences, and funding difficulties.
Yeah.
And again, those are all irrelevant. There's no detail here about how precisely, say, the funding difficulty, which seems to have been resolved with a loan, why and when that caused a delay. And it's got to be seen in the context of what we know is that, in fact, Mr. Jalaluddin had been advised that he had an appeal 5 days after Judgment 2 was handed down. And then there's another 60 days of sitting on it.
Yeah.
So there's no proper evidence of any urgency or prompt steps being taken or anything else. There's just a list of excuses which, on analysis, are, in my submission, wafer thin. And so I do in my submission, your Lordship observed 66 delays is not a long time. In this context, it is, because these are the reasons for it, and they're not good reasons.
And you urge high satch upon us.
Do you?
You do.
So that's stage 2. Those are the reasons. No good reasons for the delay. And then stage 3 is discretion. It's not made promptly after Judgment 2. So I do take the point on full and frank, and the non-engagement with the proceedings for a year after they were served. I also take a point on balancing justice, which your Lordship and I have been debating. This, because of the delay, it's come after enforcement has started. Which
You haven't enforced anything.
We've applied for recognition in Singapore.
Has it not been recognised yet?
It has been recognised, but in light of the appeal, enforcement process has been paused.
Right.
And proceedings against Mr. Salamat have progressed. And as I said to your lordships, we will be pressing, if this appeal succeeds, for FMC to join those proceedings. But no guarantee of that, and time is tight. CMC has already happened, and disclosure is set down for July.
Well, you couldn't have a fair case against Mr. Salamat without FMC if there was no judgment against FMC, because their position is intricately connected. So, I mean, like it or not, if the appeal's allowed, somehow all the parties have got to get before the court that want to come.
Yes, and my submission is that what we would be pressing for is that they join the timetable.
Yes, of course you would. Yes.
But when disclosure is next month, and FMC have never filed a defence, and the CMC has happened.
Yes, no, I get all that.
Yes, yeah, although we'll be contending for that.
So FMC's never filed a defence.
So I just want to make clear that my submission is not that it definitely would derail the trial, because I don't want to be accused of then turning around and saying, and pressing to join the trial, which would be contradictory.
How long's the trial set for?
7 days.
In front of His Honour Judge Worcester?
No, it's a different judge. Jarman. His Honour Judge Jarman.
Judge Jarman?
Yes, I believe so.
In Cardiff?
Birmingham. Sorry, Charman, not Jarman. And that's listed for April next year. So time is tight. So I do take
April 27th.
27th of April 2020. Sorry, which date in April? Sorry, it's April 2027, but I misheard and said the 27th of April, which
Just
is
April.
Yes, April 27th.
7 days. Okay, very good.
Although presumably, since FMC's case so far has been, we didn't really know what was going on, they won't have much in the way of witness evidence or disclosure to give.
That's the kind of submission we would be making at a CMC, but that's not a confirmation that we've had from FMC. And we don't. And I only put this as there is a risk of injustice.
And we may be able to, if we were to allow the appeal, which is obviously not clear, but if we were to, we could say that it would be that the matter's been too long delayed already, and that all the parties must move heaven and earth to make sure that the case is tried in April 27 at the very latest. Whether that anybody takes any notice of that, we could say that.
Well, that would certainly reduce the prejudice of that particular.
Are you sure that the judge is called Charman?
Charman.
Right.
It's Andrew Charman, who was appointed a few years ago, my lord, different from His Honour Judge Jarman.
Must have been after my time. I mean, this will be in the business and property courts, and I'm astonished that I don't know the identity of all the BMPC judges in Birmingham, but there we are, I don't say. Yeah, Andrew Charman, very good.
So in the context of a delay and dilatory conduct, the court does need to weigh in the balance the prejudicial effect on the first move.
Good. Well, I think we've reached the adjournment. Do you have very long left?
No,
Have you finished? We're going to let you take time over the agenda in order to take a resume at 2 o'clock.
Well, Ryan,